Mr. Chairman, members of the Mackinac Bridge Authority, it's a privilege to have a chance to speak to you about what I'm going to say. And I thank you for accommodating this with respect to the change to the agenda. So thank you. My name is Jim Olson. I am president of Flow for Level Water. Flow was formed originally about 10 years ago, but more formally about 6 years ago. It has one single purpose, and that is to assure that the waters of the Great Lakes Basin and the bottomlands and the soils that are protected by the public trust doctrine and the public lands and natural resources of Michigan and the Great Lakes region are managed with the utmost integrity. Our belief is that if we make really good decisions and keep in mind the integrity of water and prevent risks that are not necessary to water, that our children and grandchildren and their economy and their health and well-being will be secure. We'll make very good decisions about things like what you're facing today. So thank you. By way of background, just so you know, I've been a water and environmental lawyer, public interest lawyer, worked with a lot of local governments, land use issues for the last 45 years. I was just checking the other day and I thought, wow, I never thought I'd be a lawyer 50 years, but it looks like that's coming pretty close. My background is Michigan State Business School, Detroit College of Law, which is now Michigan State College of Law. And then I did a special master's of law at the University of Michigan in the waters of the Great Lakes, the public trust doctrine, public resource management, public lands management, parks, and all the principles surrounding publicly owned lands and waters and natural resources. And I've pretty much dedicated at least the academic side of my legal work, as well as representing many clients, doing just that, trying to solve either in a courtroom and more often not in a courtroom these kinds of issues that we face as a society. And we're at a point in history where things are coming down to a day of reckoning because of the population, the need for oil like you're talking about here today, the need for water, for food. So we have this nexus of energy and food and water that are coming to a head. And here you are faced with a momentous decision. So I sent a letter on behalf of Flow with Executive Director Elizabeth Kirkwood, who is here, a week ago to you, and I understand that you each have a copy. I hope you do. We had requested that happen, and I assume that it did. And what I'm going to do is spend 10 minutes, and then I'm going to sit down because I know time is crucial, as the chair pointed out. So I'm going to zero in on what I consider important information and education concerning the framework, the legal architecture, if you will, under our Constitution and laws in which the MBA operates. When I say MBA, I'm talking about the Mackinac Bridge Authority, not some National Athletic Association. I'm going to spend my time on that because I think if we don't get the framework right and we don't get things in the right order, things are going to go awry. And we know what happens when the rule of law is not followed. We see it time after time where we think things are all right, we take shortcuts, things go awry like in Flint, and we all have to pick up the pieces. Well, that's the last thing that we want to happen with the Straits of Mackinac, and particularly the bridge with the incredible 61-year-old history that you have. And I've read through this, and it's quite a story. So my first thing I want to stress is that under our Michigan Constitution and our laws, there are several provisions in the Constitution, Article 4, Section 30, Article 9, Section 18, 3, Section 6, that address questions of commingling or government being involved in aid of private If you're going to do that, you're going to need a 2/3 vote of each house of the legislature, and it can't serve a private purpose. So there's a long history of that. There were bank failures in the 1850s that were as bad as the Depression, the Great Depression, largely because state projects and money funneled to aid private projects, and banks failed. And we had Michigan adopted one of the first provisions nationally and had a constitutional provision that basically said no more of this. And it's been in every constitution since, and it still is in the Michigan Constitution. So the larger framework here is how far can you go, and particularly a body like MBA that has a single purpose and has a public bridge, which is in a sense a replacement of a ferry service, which is a public trust use, navigation of the waters of the Great Lakes, which is a paramount use to any other uses and is jealously protected by our law and ethics. So that's the framework in which this has to be decided. Now, why is that important? Well, I said rule of law, and the law reflects the will of the people. What you have so far in front of you is an agreement, paragraph G, in this second agreement that the state and governor signed with Enbridge, and that agreement calls upon the Mackinac Bridge Authority to play a role. So the question is, and I urge you to take your time here. This is a serious question. Why get it wrong? There needs to be a very significant independent legal analysis of what the parameters are so you understand what you're in for as members of the MBA and on behalf of the taxpayers. And I say that because the Straits of Mackinac and all the waters of the Great Lakes have a special recognition. When we joined the United States, all of us in this room became beneficiaries, and the state became the owner of the water and the soils under the water of the Great Lakes, including the Straits of Mackinac. And there's a trust duty to manage those in perpetuity, and for fishing, boating, swimming, drinking water, habitat, swimming, recreation, and all the uses and enjoyment and economy that is around that. And it can't be impaired one generation to the next. And if there are alternatives that don't need to use it, you're supposed to choose the alternative. That is the law of the U.S. Supreme Court, the Michigan Supreme Court, and it's reflected in our Great Lakes Submerged Lands Act, which requires that before you do any agreement that would locate something in the Straits of Mackinac, you have to get authority under the Great Lakes Submerged Lands Act. Back to the rule of law. The Submerged Lands Act sets up the legal structure by which this happens, and we've kind of got the agreement, the cart before the horse, the agreement before the approval from the state. And I say again, rule of law, because it doesn't matter which side we are on this controversy or not, everybody has a right to be represented by their government, to have a right of notice and participation and speaking to the issue, which we're doing here today. But more importantly, the decision body is the government. It's very rare and probably not authorized in this instance, dealing with the Great Lakes and the Straits of Mackinac and the Bridge Authority and the bridge, which has become part of the public trust. It's very rare for a government to sign private agreements or public contracts with private parties rather than go through the Submerged Lands Act so everybody gets a notice and everybody has a fair opportunity. Why is that important? Because under the Submerged Lands Act, you can't authorize it, and under public trust law, if there is a likely impairment or a risk that's not acceptable, or if there is a feasible and prudent alternative. Why? Because these public trust waters and lands, I just said, are critical in the law and paramount in the law. So, no impairment. Well, that's fine. Hear the evidence. The company, Enbridge, applies. You hear the evidence. You make a decision. You look at the feasible and prudent alternative. Everybody gets to participate. And that's what the will of the Constitution and the laws of Michigan require of you here, and the state, and the company. Not an agreement that mandates that Mackinac Bridge Authority go ahead with this, and under the laws of the Mackinac Bridge Authority, go ahead and somehow circumvent the very will of the constitutional legislature of everybody having a fair right and even level playing field of being here and participating in this under the rule of law with a decision made by the government in the open under the Submerged Lands Act, not by some agreement that basically doesn't end run on the public trust and the Submerged Lands Act of everybody in this room and in the state of Michigan, from the Supreme Court decision in Illinois Central in 1892 to the Michigan Supreme Court decision a few years ago on Glass versus Gecko. So that's my primary point here in terms of this framework. And I'm not even taking a position here on that point. I'm just saying this is the framework, and my position is that if that's not followed, and we put everything else ahead of that, we've breached the public trust, we haven't done what the rule of law requires, and it's going to have to be done at some point. So everybody should be on notice that if we go forward without that, it risks, all this time and energy risks being undone. So let's do it right. Let's take the time and do it right. What's the fear? Let's get it all in the open. My next point. Paragraph G in this agreement, which you were not asked to sign, by the way, actually mandates, it says shall, Mackinac Bridge Authority shall negotiate a tunnel to put a private pipeline in it, and possibly, if the company wants it, some other utility, should they want to do so, and the company thinks it's practical. Company gets a 99-year lease for their pipeline, and they get to use the tunnel for 99 years for that pipeline. But it says that you shall enter into a private or a public-private partnership. Well, that's aiding a private company, contrary to those constitutional provisions I mentioned. Or it could be. I'm only one opinion. And Flo tries to do things independently. We dig in deep and try to make a call. And we're just making a call. I'm one voice. But the point of it is, it's such a serious issue on this public-private partnership, not for highways. It's done quite a bit, as our officials from the Department of Transportation know. But it's usually for a public project, not for something that's basically to aid a private project. This is something new. So you need to take a serious look at that as to whether or not you can be mandated to do that by a separate agreement under the Michigan Constitution. Next point. There's been a lot of discussion about the mission of the Mackinac Bridge Authority. Well, the law is right now, it's a single mission, and the history and the culture is that. And I know that there's a 2005 amendment where the department, not you, but one of your predecessors, tried to mess with the Mackinac Bridge Authority. And some of you here on the authority know darn well what I'm talking about. And the legislature, I think all those who voted, 78-0 and 100 and something 0, prohibiting the state government to interfere with the authority of the Mackinac Bridge for its single purpose of protecting this bridge for the motoring public of Michigan. So that creates another serious question that has to be looked at as to whether or not that's even legally possible, and more importantly, the practical situation. The biggest practical situation is R2. So there's two subheadings on this paragraph G in the structure of this agreement. One is ownership. Owners are liable. Not liability. No, it doesn't insulate you from liability. It shifts, it decides who's going to pay. So if you have a contract that indemnifies you from the company, if the company has enough money or the insurance is there, you're covered. If the company abandons the line or has financial difficulties, you may or may not be covered. All right? Secondly, owners have a non-delegable duty if there are high-risk activities. That means you can't delegate your liability to somebody else. The owner is stuck. So that means the state and the taxpayer, if the monies are not right under the contract clause, the owner always gets sued, and then you sort out the money later, but the owner is liable. So you've got a major fiscal issue and a major liability issue that you need before you go any further. Now, am I over 10 minutes? Okay. 1 minute more. The point is this. There are a number of studies called due diligence, and you as members of the authority are charged with due diligence. You can't be on a board, a public board or a private board. You're charged with due diligence. Here's what we need, we think at Flow needs to happen. One is there has to be this thorough legal analysis of all the potential legal issues. Second, a fiscal analysis both for your own financing and the financing that's real and expected. And this should be done before you negotiate anything, the things I'm saying. And that lays out the finances, and it's on the table. You can't sign or approve or consent to any of this until this is on the table. Secondly, what's your oversight responsibility? And how much is that going to cost? And who's supervising it? Now, I know the department will probably provide, there's a lot of good people in the Department of Transportation. They're engineers. I've worked with them over the years. But you need so legal, fiscal, infrastructure, worst case scenario risk analysis before you go any further. Just like happened with Line 5. You can't do this and put another tunnel in there and do a worst case scenario after the fact. We've been through it. We don't need to do that again. Worst case scenario study now. And then demand that this get authorized by the Submerged Lands Act. What's happening is you're being asked to compile or gather the lands of Michigan, the public trust bottom lands of Michigan, and hand them over to a company for primarily a private purpose. Unless you go through the Submerged Lands Act, you can't do it. So you need a thorough study, and the company should be required to do that before we go any further. And boy, I really thank you for the chance to speak to you personally rather than you just reading a letter that's 10 pages long. So thank you. If you have any questions, I'll stay here. Otherwise, I'll sit down.
Are there any questions of the authority? Jim, I want to thank you as well as Brian.